Madam Deputy Registrar, can you commence the proceedings?
Thank you, President Saunders. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, monitoring hearing in CCJ appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, Council. Good morning, everyone.
Mr. Justice Anderson.
Good morning, Council.
And to Madam Justice Rajnath Lee.
Good morning, everyone.
May we have the appearances, please? Thank you.
Good morning, Your Honors. My name is Nigel Hughes, and I am with Leslie Mendez and Alistair Jenkins for the appellants, the Maya Leaders Alliance, and others.
Yes, good morning again.
Yes, good morning, Your Honors. My name is Andrew Marshalek, and I'm here together with Mrs. Samantha Matut Tucker for the Attorney General, respondent.
Yes, good morning to you, Mr. Marshalek, Ms. Tucker. And I gather we do have some visitors who are viewing the proceedings live. So we welcome you all to this compliance and monitoring hearing. As usual, as we've done in the past, maybe it would be good to have first the appellants who would give us their assessment of where this process stands at the moment. And then we may have some questions, and then that will be followed by the appellants, the respondents, sorry, who would go through a similar process.
May I please, Your Honor, with your permission, may I invite or ask Ms. Leslie Mendez to provide that report?
Yes.
May it please Your Honors, we have presented the report to the court, and I highlighted therein. From our perspective, there has certainly been virtually no communication between the parties since the last hearing. This is despite a request that was sent by the appellant for an update. That request was not even acknowledged. So at this point in time, we are at a disadvantage in terms of appreciating where we are with respect to the key steps that need to be implemented on the basis of a lack of information. It is only through the report, in fact, that we have some insight now as to what is being proposed now in the policy after the meeting that we had and following the written comments that we presented. However, to our disappointment, it still seems that the general approach, the essential approach of the government has not changed, in that essentially we're still dealing with a formula, predetermined formula based on population size as how we will proceed with respect to the delimitation, Your Honor. Our issue with this is that it does not reflect and it pays very little regard to the actual patterns of use and occupation of each community. It pays very little regard to the features of each community, so that all it does is that it implements or it imposes a particular sort of map onto the communities without a real appreciation of the identity of the community itself. We also note that the government is also continuing to draw from the doctrine of adverse possession on this point. As we had attempted to explain or to reach out to the government to indicate that in our view, it is discordant with the cases and with the spirit of the consent order itself to be drawing on adverse possession to impose on the communities, indigenous communities, the standard that we would impose essentially on squatters for them to be able to establish a claim of customary land tenure. Of course, at this point in time, Your Honors, we are reacting to what is in the report itself, as we have not been provided a copy of the draft policy as has been redrafted now. That is where we are currently, Your Honors.
A couple of questions on the delimitation issue. Have you, both on the delimitation issue and on the methodology, you said that the government has or is seeking to impose an adverse possession methodology. On both that issue and on the delimitation issue, have you provided alternative approaches to the government?
Yes, Your Honor, we have provided alternative approaches. We have invited and urged upon the government for mainly the first point is for us to meet, to revisit the methodology that was developed, which is the DPM, the delimitation principles and methodology document, because that's what's guiding the communities currently on the approach that they take with respect to delimitation. And then with respect to the threshold, which was the center of our discussions at the meeting, we have provided alternative to the threshold that should guide where Maya customary land tenure will be affirmed and confirmed. And that threshold that we suggested to the government was, instead of imposing on the communities to establish something akin to adverse possession, that there be a freezing point, and that point would be the 2015 consent agreement, where at the time what the communities have to be able to establish is that what is it that they were using and occupying on 2015, in the year 2015. And that is what would then guide the threshold and also address any concerns that have been raised with respect to communities grabbing land after the consent order. So that is what we have proposed in our communication to the government.
Okay, I want to understand clearly the divergent positions in relation to that last issue. The appellants are saying, your side is saying that the government is proposing that the government should take what actually was being occupied as a 2015 as the point at which you determine what constitutes Maya land, if I may put it that way. And you say that the government is suggesting that in lieu of that, each community should establish for 30 years going back that it has occupied the land that constitutes what is to be regarded as comprising Maya land. Is that your understanding?
That's my understanding, Your Honor, that the communities would need to establish 30 years of continuous occupation, use and occupation of the land.
Ms. Mendez, I had, President, if I may,
Sure.
I had thought that I had read that what the government was proposing was a sort of a hybrid approach, and there would be an automatic recognition of Maya customary land tenure, and there was a formula of 5 acres times the population of the village. Is that something that has been agreed?
No, Your Honors, that's the first step that we indicate that in our view, what that presents is a predetermined universal formula that would apply in each village that does not necessarily account for the particular features of the village and the actual actual patterns of use and occupation of each village. And then with respect to the second stage of the approach, what we're saying is that the idea, as I believe the government presents it, is that we start off with a minimum, but that's not necessarily restrictive. You can always apply after. But the point is that in the criteria that is being proposed as one that you can apply after, our position is that it is restrictive, and ultimately what it does is that it treats the communities as squatters, because effectively they are being asked to meet the very same standards of a squatter. So
I understand that. I understand that. And you said it before. But there's something that I'm trying to understand. How does the formula that we can refer to as adverse possession, how is that unfair to your clients? I had thought they had met that a long time ago, that standard, that threshold. That's what I'm trying to grapple with, the unfairness of the standard that is, or the threshold that the government is suggesting.
Well, Your Honor, the thing is that in order for you to be able to establish that as well, you have to be establishing also that it's undisturbed. And so there is a conflation in our view with the delimitation and with the treatment of third parties. And so that if there is a third party interest, effectively you cannot claim that area. And so it's in our view that the burden of establishing the evidence of 30 years continuous possession brings in a very messy process. And it is, in fact, a very high threshold for the communities to meet. The patterns of use, the patterns of use and occupation of the communities is also quite not necessarily reflective of this standard continuous use, Your Honors. There are some spaces that are left completely unoccupied, but that is based on the use, on the patterns of use of each community. So we, in our view, it's not a workable formula that is being proposed, Your Honors.
Yeah, I think I understand it a lot better. One thing that you said, there may be some parts of the land which are unoccupied by your clients, but I say that they may be occupied by third parties. So I think that is where it gets complicated. Thank you, President. I think I follow what Ms. Mendes is saying.
But I want to go back to your understanding, Ms. Mendes, of the formula which is being proposed. And we'd hear from Mr. Marshallek in due course. And I'm sure that there's a lot of this back and forth that hopefully he will clarify. But my understanding from reading the documents that were submitted is that the government is proposing to accept the villages that are already constituted villages, but I agree to you, it is imposing a limitation on the size, which they have capped at 5 acres per head, 5 acres per person.
Per person.
Yeah, per person. I don't know on the ground to what extent that augments or limits the existing space that is occupied. We haven't had no indication of this, but that it would be interesting to find out. So that is a little different from your earlier statement, which suggested that there wasn't going to be any recognition of existing villages, but that rather a 5 acre per person formula was being arbitrarily imposed. As I said, we would hear from Mr. Marshallek a little bit about that. Yes, go ahead.
May I comment?
Mm-hmm.
The comment was generally with respect to the approach that is being now adopted or now proposed. with this, we should bear in mind that many communities have already been in the process of delimiting their lands in accordance with the previously agreed methodology. It was not an attempt, it was not to suggest that there is no, that the position of the government currently is that lands will not be recognized. But it's a comment on the fact that what is being proposed as the first step is not necessarily sensitive to the actual features of each village. That was the point that I am attempting to make to the court. We also don't know, Your Honors, because as we've mentioned, this is the first time that we are hearing of this second proposal, so to say, from the first circular scheme, as we called it, that we raised concerns, and now we have this other proposal. We have not necessarily had the time to see how, in fact, as Your Honor indicated, it would actually affect on maybe augmenting or restricting the lands that each village recognizes as its own. It's certainly something that we will endeavor to look at, but it's a reaction based on what is in the report currently, Your Honors.
Mm-hmm. And the last thing is that I thought that the 30-year adverse possession proposal only related to lands which fell outside of the 5 acres per person construct, and not, as you suggested, and I don't know, you may be right and I may be wrong, but I this is how I understood it, that outside of the 5 acres per person construct, if there were proof of 30 years continuous and undisturbed possession, then that would also be put into the pot, so to speak, but not that the 30-year continuous and undisturbed possession will apply to the entirety of the lands that would be regarded as Mayan lands. But
yeah, just to clarify, that is how we understand it as well. And so
yes.
Perhaps I was not clear enough in just my initial comments and reactions to what is there. I was simply commenting that in our view, a formula without looking at the specific village and their use of patterns is arbitrary. And so the formula that seeks to automatically recognize an area of land, we recognize that that is how it would work. And then to accommodate any other feature, then what is being proposed is something akin to adverse possession, which we also say would be inappropriate in the circumstances. But just to clarify that it is exactly as Your Honor has described it, what we understand. It's effectively a 2-tier process, where first you would have this automatic recognition, but if you want to claim more, or if you say more belongs to you, then you have to meet this threshold. But ultimately, those two don't seek to actually look at the specific features of the patterns of use, as well as the specific features of each community.
Okay. All right. Is there anything else that you wish to urge on us at this time?
No, Your Honor.
Yeah. Okay. So, Mr. Marshallek, Justice Anderson, anything from you?
No, not at all. I'm very eager to hear Mr. Marshallek.
Mr. Marshallek, the world waits on you.
Yes. Morning, Your Honors.
Morning.
Your Honor, I have to first off by saying that nothing is being imposed or implemented. This is still in process. In fact, presentations were made to Cabinet this week, and they've expressed some concerns, 3 sets of concerns about what was put up to it by the subcommittee. So nothing is being composed. I wanted Your Honors to appreciate some of the difficulties we're encountering as to explain why I am not able to respond to my friend, because I don't want to engage on argument on just ideas that are not being implemented. We've already explored those ideas with the other side, and we have their recommendations in writing. And certain views have been taken, differing views have been taken in relation to it.
I want to stop you there. Are you satisfied that you, and by extension, I mean the government, has a good grasp of what the appellants are proposing on these various issues?
Yes, I think so. The delimitation principles allowed for self-delimitation, so they go establish their boundaries, and then there's this expectation that wherever they draw them, those lands would be titled in their favor. There's been acknowledgement that the state would have to verify use and occupation, some standard of use and occupation before titles can be issued, even under that delimitation process. So that what that process is getting an indication of size and the gathering of proof to show use and possession. And then there still needs to be some process where all that's verified before it's titled. That process has gone on for the entire 10 years. I think we have 3 villages. So it hasn't produced very much results. And I think Your Honors will remember that it's a concern that I've always expressed, that if we wait for that to be finished, we probably never get anywhere. The alternative proposed from December last year, when the full cabinet, the government, approved a draft for circulation for the purposes of consultation, was to propose the automatic recognition of a circular area defined by reference to the radius from village center, because the evidence of the anthropologists in the claim below, first instance, was that that's how living spaces were defined. Within so many kilometers of village center, people lived. Within a further radius, people farmed. Within an even further radius, people collected forest resources, hunted and fishes. So the Maya village system was described by reference to concentric circles. So we sought to automatically recognize all the living spaces and then allow for the farming areas to be applied for, so that the boundaries can be established organically over time once all the applications have been heard and determined, which I expect will take some time given the different interests involved in the different claims to that same space. So that met with very strenuous demonstrations in January last year. I think your Honors will remember. So it was taken off the drawing board and we went back to the drawing board. And the first change was to say, well, look, if you don't want an automatic recognition of any circle, then we'll just say prove use and occupation for everything. That led to our meetings in May, when certain criteria was suggested. And the criteria suggested is really that, well, everything that we've used and that we were using and occupying as of April 2015 would be recognized, and nothing after. But that didn't take matters very much further as far as we were concerned. So what we came up with, and it was a suggestion, and I'm explaining this so that Your Honors can understand how the thinking has evolved over the months, is that there be automatic recognition of a space that if you don't like the delimitation being expressed in terms of a radius of a circle, expressed in terms of what lands are normally required to sustain life of a person. This per capita requirements and some international standards, although they seem to be all over the place. And that's where the 5-acre proposition came for, because the thinking is that 5 acres per person is more than enough to sustain life. So we'll say at least that to preserve these villages, they should get at least that automatically. No proof of anything, just get that. So that anything that falls within that area, any third-party titles would automatically be extinguished and would give rise to claims for compensation against the state.
One small point here, Mr. Marshall.
Yes.
When you say per person, is that per adult person?
No, it's per person. Adults and children, everybody.
So each person would be entitled to 5 acres?
Well, no, the village is entitled to a space that is measured by reference to that metric. It's not that you're giving each individual.
No, I understand you, but but the formula is calculated based on every living human being.
Yes.
In that village. Okay.
So a family of 5, you're talking 25 acres. To put it in context, Yes, it's every living human being, because the metric that was used was what space does a human being require to sustain life, and that was how that metric. That's how that suggestion came about. So it's a starting point, and it establishes a nucleus from which additional claims for additional lands can be made, but based on some standard of possession. The thinking is that the governing criteria here should be whoever is in possession of those lands and in use of it should really end up with it. And that's the thinking.
Outside of what would constitute the 5 acre per person.
Yes, outside what is required to sustain life in these villages, a reasonable allowance for that, which everybody accepts it should be given automatically. But it's also about establishing a process for these boundaries to be established organically over time, because we recognize that on the date this legislation is passed, you probably won't have those boundaries established in all likelihood. With regard to the 5 acres per person, not taking into account the actual position of the village and villages on the ground, that delimitation as to acreage, as to overall acreage, is just that. It doesn't say where it has to be. The process of auto delimitation, you still get to identify yourself where that's going to be, but up to the outer limits stipulated. That I can say has not been accepted. The idea has been accepted that there should be automatic, a hybrid approach, and going beyond that, there should be proof. As to how we express that delimitation, there is still discussions going on around that. And this is precisely why I don't like to communicate it at that stage, because then we get into fights that maybe we don't need to engage on. Yes.
Okay. Mr. Marshall, the only thing I would say is that, well, you see, both sides have been having discussions and meetings and consultations and so on. When we saw the compliance reports on this occasion, and the appellants have said it themselves, that they were seeing for the first time the proposals that were set out in your compliance report. And that's a little unfortunate. I mean, even though that you could have said it to the court, but it hadn't been said to them, I think it is more than unfortunate.
Well, where we are with that, Your Honor, if I can just clarify, because this is what explains that. I am not making that as a proposal. I was giving it as an indication of what was being proposed by the subcommittee for consideration of the whole cabinet, not what was being proposed to the other side, because no proposal has in fact been made to the other side. What I'm saying is that if we engage on all the thinking at those steps in a way, we just get into unwarranted skirmishes like we are now, because we're still not settled on exactly how that should work. There are several thinkings on how to delimit that. There are several lines of thought, and I can say what they are, but they will just provoke strong reactions. So the idea was not to get into that until the government side is itself settled as on a method, and that's all it is. So
okay.
I had intended it as an indication, not that we're proposing it, because it's not being proposed. It's not being proposed just yet.
So if I understand you correctly, after the government has decided on the proper, on the manner in which they would like to give effect to the policy, that would be stated in a policy document or a bill. And at that stage, there could be scope for further discussion.
Yes, well, where we are is we settle a policy. The settled policy will form the basis for the instruction to the draft person. And then the draft goes through all that consultation process again. But we haven't moved to drafting because we haven't been able to settle the policy. And since May, I can tell you we've gone through 4 versions. As I said, I disclosed what I did to the court because I wanted to give some indication on the kinds of thinking that has been informed on the difficult decision that needs to be made. But I think after having had certain decisions made on Tuesday, I think we're very, very close to putting out a policy that the government is comfortable saying this is a policy that we intend to approve or we have approved. But we're still not there yet. And while I appreciate that the other side wants to be kept abreast of everything, I don't want to engage in unnecessary skirmishes and create unnecessary tensions, especially over ideas that might very well not go very far or take root. We've been pitching these ideas as ways of finding some perfect solution to this, which we already know doesn't exist, but trying to find the best accommodation possible. At this point, I can say that I think we're satisfied, the government is satisfied that the hybrid approach is best. As to how exactly the automatically recognized areas would be defined, I think needs a little more work. And as to the standards of proof going forward for the additional spaces, proof of use and possession, I think that needs some work. There is a preference to rely on adverse possession because that adverse possession would have displaced third-party titles in any event and would limit the compensation that government would be exposed to persons with holding land titles in these spaces. I mean, those titles would have been subject to loss because of adverse possession anyway. And that was the reason why that approach was being preferred. But again, it's not finally been settled. It's still being bounced around, but that's where we are just now. That's where it's tending. That's the direction it's tending.
Thank you.
Yeah.
Ms. Mendes, through the court, is there anything that you wish to comment on, to seek clarification on, to the extent that there is anything that could be clarified, given what Mr. Marshall has said?
Yes, Your Honor. It's just a couple of things. Just in reaction to what my learned friend, my learned senior has indicated. Firstly, Your Honor, I just want to establish or express that in our view, the in-person meetings that we've had, I would have thought, and I thought, that they had established a level of trust and confidence that I think that at the very least, we would not be seen to be overly reactive, right? So that if something is presented to us as a very clear proposal that is not at all firm, but rather to get preliminary thoughts or a reaction from us, even if informally there was the space for that, so that we would have already inquired how the 5 acres might work, how it might not work, for instance. So I just want to communicate that and to express and to remind ourselves in a way that I think that we have had some fruitful discussions. And so these tentative proposals or these ideas can certainly be shared with us, and we are mature enough to understand that they are but ideas that are being thrown around. The second point, Your Honors, is that with respect to the 5 acres, I would just want to emphasize that when we think about communal land rights, we're not only thinking about the individual. So it's not only about what the individual requires to sustain life and to live, but rather what is required for the community as a whole, as a Maya community. What do they require for them to be able to sustain and preserve their lifestyle and their spiritual and physical sustenance? So just a reaction to what was said that I think reflects a little, one of the points of diversion sometimes that we have in our discussions, that ultimately what we're looking at is the community as a whole. And then lastly, Your Honors, in terms of a clarification, I would like to, I think the the exchanges currently with the court and my learned senior, I don't think I was clear. Is it that the policy is settled, or is it that we will have an opportunity to still review and to provide comments? Because in the compliance report itself, it seemed to have been a shut off option at this point in time. I thought it was settled, but it might not be settled. So just seeking clarity on that and seeking clarity on the legal drafts person, Your Honors. Thank you for the opportunity.
Yes, thanks. Mr. Mashler, could you shed any light on the last two issues? Clarity on the legal drafts person and also whether the policy is settled. Well, I did think that you had said that the policy isn't quite yet settled yet, but
yes, I think it's close to being settled. It's not settled. There were 3 items raised that needs to be fixed or reworked that didn't meet with the approval of the government. So we will settle that in the course of this week. And the thinking was that when it's settled, that would be declared as the policy and used as a basis for instructing the draft person. So the further consultations come with regard to the draft, consultations on the draft. The thing is, I don't think we'll ever be in a place where both sides can agree to the policy. And if we allow more time for it, as much as we would like that happy position, I don't think we'll get very far with drafting. We've already gone most of this year trying to reconceive the policy to try to come up with some compromise position. And in fact, the hybrid position is a compromise position. It's employing both approaches to come to an overall final solution. So that needs to be tweaked.
Mr. Marshall, can I ask then just a further question on that, please? When is it that you hope to get the instructions to the draft person?
We got the comments on the existing draft and what needs to be fixed this week. By next week, we would have fixed it and represented it to full cabinet for their final sign off. Once they sign off, then it goes to the drafts person. We had considered the list of drafts person and had settled on a name, but we haven't contacted the person because we really can't properly describe the job that will be required of them to get quotations and settle a contract. So the draft really needs to be settled first, and we're very close to it. I think you will see that it will be a hybrid approach, some automatic recognition, which I think is good for everybody. And it has to be some reasonable way of deciding who gets the remaining lands, whether these other third parties in possession of titles would get to remain there, or they too will have to be displaced, and what criteria will be used to draw those lines.
Okay. This is a matter of interest. Sorry, go ahead, Justice Anderson.
No, I just want to be crystal clear. So in relation to the question asked by counsel for the appellants, the answer is no.
No. Yes.
That there's not going to be an opportunity to contribute any further to the formulation of the policy, because once that policy has been agreed by the cabinet, instructions will emanate from that policy to the draftsperson. Is that right?
Yes. But they're not set in stone in that there can be refinements to the draft. The policy is an overall guide, so I'm sure that the overall approach would be set in that it would be hybrid. But I would think refinements can be made even to the draft legislation.
I understand you. So there are a few questions I want to ask you on the policy, and I know it is a work in progress, as you have indicated. One of the things you touched on, and then you moved away from it rather quickly, and you may not be able to shed any light in this context, but I am curious as to how the established villages will be identified, because that's a category that is not reliant upon the adverse possession concept, as I understand it. You're saying that these are established mine villages, they are entitled to the acreage based on the population.
Yes.
Can you share with us how those villages will be identified?
By way of the self-delimitation process. They will identify their boundaries, but within the overall limitation as to acreage.
I see. Okay. So it's only when the acreage exceeds the formula that you have established that the issue of further entitlements based on 30 years occupation becomes effective, all right?
Yes, but from indications from what we've had on the indicative map, we expect that they will all exceed as they go to cover pretty much the entirety of the Toledo district.
I understand it. So that your formula, when superimposed on the original formula put forward by the appellants, is likely to come up short because they would be claiming much more land than it's likely that your formula would indicate that they're entitled to. Am I right?
Yes. It's about getting a nucleus settled that everybody can agree to right away and giving titles to those spaces. And then we can work through all the competing interests for the remaining over time.
Yes. I'll be interested in Ms. Martinez's response to that. I wanted to ask you further on this point. Personally, I must say it's a very intriguing idea. And I note that you sought to indicate why you thought that the 5 acres per person formula was an appropriate one. Can you say if that identification, the usage of the 5 acres per person, is something that is consonant with international jurisprudence, international law? Is there any other circumstance where this kind of formula was used, or are you creating this as something you consider best useful in the Belizean context?
Well, again, I'll rely on the latter. Internationally, you could find some measurements, some studies done. They come up with less than 5 acres, the ones I was able to see, but I'm sure there's a range. In Belize, the 5 acre per person has been used in relation to other indigenous communities.
Have you, in coming up with this formula, consulted international law experts on this?
No, we haven't gotten there. As I said, the idea itself, I think we will move away from it.
I'm sorry?
I don't think that will go forward.
Oh, you don't think it will go forward?
No, I don't think that expression will go forward. I don't think it has met with, it's been met with that kind of favor. The idea, the concept of recognizing some space automatically and finding another way to redefine it.
That's one of the sticking points with the process.
Yes.
I see.
That's where we are. So no, we haven't gone out that far with it because the idea was being pitched. And this is one of the reasons why I didn't want to put too much weight on it. But it's just to inform the kind of thinking. But if there is an international standard, we would be happy to, and it can be shared with us from the other side, we'd be happy to take a look at it. But there are some other options being proposed, and I suspect those might find more favor.
I see.
So I don't want to get stuck on 5 acres per person because I don't know how we will go there.
Yeah, well, that might be an opening, Ms. Martinez, to research international jurisprudence and try to assist the government in the formula that is eventually adopted. I wanted to ask you as well, please, Mr. Marshallek, about the quality of the rights that will be enjoyed. Because at the moment we're talking about geographical areas, but is the policy also going to speak to the substance of the right? Is it sort of fee simple in the sort of common law tradition? Is it something different? Will the villages be able to rent, to sell? what I'm trying to get at is the bond of rights which will accrue to the villages under the proposed scheme. Is that being also described in the policy and the legislation?
It's been described in the policy in a general way, in that there's still details to be worked on. What the policy says is that the interest will be sui generis of its own kind, called Maya customary land tenure, and it will include all the rights of use that has customarily been practiced. So it's a way to capture how it was, give it a formal definition, and then protecting it. And that's the concept of the policy. Now, there might be some thorny issues there that need to be confronted, but the policy doesn't go further than that at this point. So that's for further working out, identifying exactly what that is. But what the policy does say is that there will be an effort to capture the customary uses and practices and incorporate that within a new interest, which is to be called Maya customary land policy.
And that will be registrable, I take it?
And that will be registrable, and a title would be issued for it. And the idea is to incorporate this within the existing registration system so that that proprietorial interest would be noted on the register for that land, and certain consequences will follow. Yes.
Finally, the issue of the timetabling, because as the president has indicated, I think my sister as well, Justice Rajan, there is a fixed period that we're working with. We gave the order, this court gave the order in, I think, April 2015. 10 years is going, and we really want, and I'm sure the president is going to emphasize this point, really want to arrive at a tangible landmark to say, yes, we have achieved something. I know we've done some work on the FPIC, and that is to be commended, but this is a critical, crucial core area. So can we look forward to the tabling of the bill by April of next year? And if we're going to do that, how are we going to include the contribution from the appellants in terms of consulting, whether on the policy or on legislation as drafted?
Yes. I expect this is why I've been pushing for the policy to be finalized and for us to go to drafting, and we've been stuck on the policy. I think it's just a hurdle we need to push past, get to drafting, and see how we deal with the draft itself. The structure for dealing with draft was agreed with the other side. There's to be a committee to review it and generate a report and make recommendations. I don't think we have an issue there. We had settled that already when we settled the roadmap. So the same procedure would be followed. Just the dates, the timelines would have to be pushed backwards. In terms of how I see it, I don't think you will see a bill by next April, but you might get a draft. I'm not sure that everybody will have agreed on a draft by then, but there's going to be a draft. We're going to be that much closer to it. That's why I see it. I expect that when this draft is produced, the process there will be variances on how we see things should happen.
Put another way, when do you think we could see the draft that people could discuss?
If we can get this policy settled within the next 2 weeks and a draftsperson engaged, I think they'll have November, December. Maybe you see a draft by January.
January, okay. Well, if we work towards a draft by January and we work diligently and in good faith, as I'm sure both sides are working, why can't we aim for April?
We are aiming for it, Your Honor. We have it firmly in our sights. Good. I'm just saying that realistically, given the way how things have developed with the policy, I'm not sure that we'll get there, but we'll certainly try for it.
The past need not be a precursor, you know. We are aiming for a goal and we want to achieve that goal. Through you, President, I'd be anxious to hear the views of Ms. Martinez on this, but I think all of us here would love to achieve something by April.
Yes.
Yeah, okay, if I may, Mr. Mr. Marshall, like you were speaking about the agreed procedure going forward once there is the draft.
Yes.
That is in the roadmap, you say?
Yes, it is.
So there is
And-
a committee, just expand a little bit for my benefit, please.
All right, I don't have it in front of me, but we had agreed on a review panel there to appoint 2 members. I think we're to appoint 2 members. The review panel reviews the drafts and generates a report. The report, together with draft, goes to the subcommittee. So then government gets a say. And that's the structure. So we get to both have a full say and collaborate on what we think the draft could be. And if there can be no agreement, there will be a report going forward, I imagine, setting out all the reasons why. And then it goes to the decision maker to see how, I guess, it can be reconciled or what will be recommended. And then it goes to the full debate of everybody in cabinet, which generally takes on its own flavor.
Thank you very much.
Okay, is there anything else that either of the parties would like to state at this point?
Yes, Your Honor, just 2 points.
Yes.
Well, 3 points. The first one is that I miss Mendez, not Martinez.
I beg your pardon. I'm so sorry.
I think Justice Anderson has married me out. But yes, just 2 points. I will say that we are definitely pleased to hear from my learned senior the openness with respect to international standards and regional standards. We have set for next week a working meeting with the support of the Inter-American Commission on Human Rights. And so we hope that that provides a space where we can continue discussing the policy and we can reference international standards. And we look forward to those standards being actively engaged with and us discussing how they can be adapted to the current circumstances. The other point, Your Honors, that I wanted to clarify as well is that with respect to the manner in which delimitation is happening currently, we do have not only 3 villages, Your Honors, we now have 29 villages that are very close to finalizing their boundaries. It's 90% of their boundaries, Your Honors, that have been finalized in accordance with the agreed upon methodology that was established under the DPM. So we are seeing some progress there. And then just a reaction with the hybrid, which I understand my learned senior to be saying that it will definitely be some form of hybrid approach, but perhaps the standards and the threshold that will be required under each stage, perhaps there's still some flexibility there. Just to emphasize, Your Honors, that when the communities launched this claim and engaged in this series of litigation, what they were mostly concerned with, Your Honors, was the resources outside the center of their own villages that they depend on for various reasons. And so the benefits that really come with the hybrid system, with the automatic recognition of that area of land, we still question why is it that we want to do a 2-tier system, because the first tier, which is to recognize automatically the center of the communities, that was never quite under threat. The threat really has to do with very valuable resources that they depend on that is outside. So that's why the hybrid system, at least to the communities, is not really resonating as something as attractive as perhaps it is for the government. But I will just end there, Your Honors. Those are just a couple of the reactions that I had.
Could I ask you, please, in terms of the timetable that we were discussing earlier, do you think it's, given all the obstacles that you perceive and the challenges you perceive, what do you think is possible by April of next year?
In my view, the very first draft of the law, Your Honors. The very first draft.
Very first draft.
Review panel. So I could imagine that is something that is a bit more realistic for then the review panel to then do what we hope is a technical review of the law.
And how much longer beyond that point before you think realistically it could be tabled in the Parliament? I mean, I know a lot depends on cabinet, of course, but from your point of view, how much longer?
I think I'm at a disadvantage, Your Honor. I'm really not certain after that. I think that the review panel could provide a comprehensive report within a month from the first draft of the law, Your Honor.
Okay, thanks. Thank you, President.
Yes. Mr. Marshallek or Ms. Tucker, you wanted to say something?
No, Your Honor, I don't disagree with what has been said in terms of timeline. And I'm not entirely surprised about the objection to the hybrid approach.
Yes. Okay, actually, Justice Anderson, I think our judgment was given on the 30th of October in 2015, if I'm not mistaken. Yeah, so if we're looking at a 10-year period, then that would give us a little bit of time. But nevertheless, it would be useful if we could still use April as a milestone, as an objective to aim for, at least in terms of the first draft of the law. Council, I think that this has been, as usual, a very helpful exercise. In a sense, I could understand the government's position, Mr. Marshallek's client's position in terms of the explanation given for what seemed to me when I read the compliance reports as almost a cessation of dialogue. But at the same time, I think it is always useful to exchange ideas. I am very heartened to hear that the appellants are going to have this consultation with the experts in the Inter-American system. And I would hope that if there are particular recommendations, proposals, suggestions coming out of that consultation, that those would be forwarded to Mr. Marshallek, to the government, so that even if there isn't dialogue, at least there is exchange of information. But of course, I agree with you, Ms. Mendez, that dialogue is always better and produces a greater level of trust and collaborativeness between the parties. We've been engaged in this exercise of trying to monitor compliance with a very difficult order to implement for 9+ years. And I do think that it has been a very useful exercise. Frankly, the precedent for this kind of monitoring of a court judgment is one which we borrowed from the Inter-American system. But it has proven to be extremely useful, and in the past, both sides have acknowledged its utility. We would like to get to a point, though, where it wouldn't be necessary for us to continue to hold the hands of the litigants. And hopefully we will get to that point sometime soon. At this point, I want to indicate that we have had present in the virtual court that we have in the court, it's a court, the presence of representatives from the Inter-American Court and the Inter-American Commission, Ms. Maria del Pilar Gutierrez and Mr. Jorge Mesa. I don't know if there are any other representatives, but given that there are parallel proceedings, parallel processes being carried out with respect to this process of satisfying the Mayan community in Belize, or at least taking good faith steps to, if not right the wrongs of 400 and 500 years ago, at least to recognize those wrongs and to take appropriate measures in the context of today's realities to implement measures that will provide a measure of justice to people who have been treated in ways which we now call genocide. And we certainly applaud the government of Belize for the good faith steps which are being taken in order to live up to that noble aspiration which they have inserted into their constitution, which the people of Belize have inserted into their constitution, to recognize those historic wrongs and to do something tangible about them. I wish to commend both Mr. Marshallek and Ms. Mendez for your forthrightness, and we can perhaps schedule another of these sessions. I don't know if we want to propose a date, maybe sometime in the new year. Let me just look at my calendar.
Yeah, and there are a number of things, President, that I was wondering whether we should take that into account, that notion that there are some developments to occur in terms of scheduling the next hearing. I believe there should be a revised roadmap. I think everybody agrees on that. The agreement on the policy, which involves, of course, cabinet, and the sharing of that policy with the appellants for their reaction. The appointment of the draftsperson, I think, as well. So I don't know then whether we should schedule our next hearing with an eye towards these things having been done. And if so, where would that put us in terms of next year, early next year?
Right. Maybe we should hear from the parties. Mr. Marshallek, would you wish to suggest a month or a time when we could return so that we can, get an update on those various items that Justice Anderson has just mentioned?
Yes, Your Honor. In terms of the sharing of the policy, I think that can be done within the next 3 weeks. The next 3 weeks, realistically. The appointment of the draft person, we can shoot for within the next 4 weeks. Assuming the draft policy gets approved, we can make the appointment within another week or so. The revised roadmap can always be readily produced. The trouble is the revised dates get missed. So it's only a guide, but it's not difficult for us to push everything back by that. So we can do that fairly quickly. So given the next, if there's to be a compliance hearing in January, we can say share policy by end of October and share policy within the next 3 weeks and appoint draftsperson by the end of the month. And then that gives a full month into drafting by the time we meet again, hopefully.
So you think then that by the time we meet next time, the draftsperson would have generated a draft? Is that what you think?
Haven't had any conversations.
I know.
with the draftsperson.
I'm just asking, Mr. Marshall.
I'm hoping we have, Cabinet has approved the appointment of a consultant, so it's not going into the usual drafting process, which should speed it up because you'll have somebody engaged just to do this. But I don't want to hazard a guess as to how much time they say they will need, but we certainly try to have something to get going with by the beginning of the year. And again, I expect the draft to go through a number of iterations before we finally get it. Yes, where it's to be.
So perhaps, Ms. Mendez, do you wish to say anything here in terms of timing and a date for our next compliance hearing?
Yes, Your Honors. January works for us, but I wanted to make a suggestion. If it is possible to meet with the government, for the parties to meet after the policy has been finalized, in the event that we would want to ask some questions as to what exactly is being proposed and get clarity on the thinking behind it. I think that would be especially useful for us that are currently, in fact, in a process of delimiting boundaries. So that would be the suggestion, that after the policy has been settled, if the parties could meet and to understand and appreciate what the policy is. And again, it's our hope that we can still have an opportunity to impact or to provide our comments. But importantly, I think it is a space where we would be able to ask and appreciate what is the thinking behind the policy itself and how it can work.
We have no objections to meeting, Your Honors. And I can say that the meeting for next week with the Inter-American Human Rights Commission will involve us as well. So we will be there. So there's a chance for us to interact then. But we have no objections to meeting, say, the first week in November.
Excellent. Okay. Okay. I think that maybe the end of January, sorry, might be a useful time for us to come back here and for the court to be apprised of what progress has been made. I want to suggest Thursday, the last Thursday in
That would be the
January.
30th, sir. 30th.
Right. Thursday the 30th. By which time, hopefully, the roadmap would have been revised, a draft person would have been appointed. We can't commit the drafts person when we don't even know the drafts person's disposition. But
sharing of the policy.
The policy would be shared. And
meeting
the parties would have met. So that if we could get those, at the end of January, we can get an update, a report on how these things have progressed, then I think that would serve all of us well. So I want to thank you all again.
Apologies, Your Honor.
Yeah.
Apologies, Your Honor.
They're not giving a date, I just said the week before.
The
compliance reports, President.
Right. We would need
a week before.
A week before, or 2 weeks.
2 weeks. 2 weeks.
So we meet on the 30th, and the compliance reports come in by the 16th.
Yes, that's fine.
Is that the same report Your Honor was just referring to with respect to providing a report to the court on these different matters?
Yes.
Is it
just a general report giving us, as you have done on this occasion, your assessment as to where things are, your report on the various steps which we hope will be taken, that we have alluded to, and just your sense of what progress has been made and what concerns, if any, you have. Yep.
And I think that's so useful, President, because this report we got from the government was quite comprehensive, and we were informed about activities relating to the EPIC, which we thought was very useful. And I think as well, there was a report on a case that's making its way through the courts on judicial review. And while, of course, we don't want to make a comment on it, I think it's useful to know what is happening in this other aspect as well. So in addition to these specific items, if there are other things that touch on concern this case, I think it would be useful for us to be informed. Thank you.
Okay. All right. All that remains is to wish you all a good day. And I am very hopeful that when we meet in January, we would have made some further progress in this matter. Madam Deputy Registrar, you may close the proceedings.
Thank you, Your Honor.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatli. Thank you, Counsel. And thank you to the observers from the IACHR. Thank you also to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.